the honourable member for Edmonton St. Albert.
Thank you. Thank you very much, Mr. Speaker. I am pleased to join the debate today on Bill C-10. As the honourable members of this House know, Bill C-10 contains provisions from various bills that were introduced in the previous Parliament and unfortunately were blocked by the opposition. The focus of my remarks today, Mr. Speaker, will be on the amendments to the Youth Criminal Justice Act. The proposed changes to the Youth Criminal Justice Act reflect what we, as parliamentarians, have been hearing from our constituents. We're concerned about the threat posed by violent young offenders as well as by youth who may be committing non-violent offences but who appear to be spiralling out of control towards more and more dangerous and harmful behaviour. Mr. Speaker, talking to fellow Canadians, we have found that they can lose faith in the youth criminal justice system when sentences given to violent and repeat young offenders do not make these youth accountable for their actions.
That's right.
The package of Youth Criminal Justice Act amendments also responds, Mr. Speaker, to issues raised during cross-country consultations, to key decisions of the courts, to concerns raised by the provinces and territories, and to the positions put forth by the many witnesses who appeared before the Justice Committee during its study of the former Bill C-4. Mr. Speaker, the reforms reflect the widely held view that while the Youth Criminal Justice Act is working fairly well in dealing with the majority of youth who commit crimes, there are concerns about the small number of youth who commit serious repeat or violent offences. Mr. Speaker, the proposed amendments to the Youth Criminal Justice Act are found in Part 4, Clauses 167 through 204 of the Comprehensive Safe Streets and Communities Act. With a few exceptions, the proposed changes are the same as the changes that were proposed in the former Bill C-4, also known as Sebastian's Law. Bill C-4 was introduced in the House of Commons on March 16, 2010, and was before the House of Commons Justice and Human Rights Committee, of which I am and was a member when Parliament was dissolved prior to the May 2011 election. As I have indicated, Mr. Speaker, most of the Youth Criminal Justice Act provisions in the bill now before us were included in the former Bill C-4. However, after C-4 was introduced in Parliament, a number of provincial attorneys general expressed concerns about the proposed amendments to the Youth Criminal Justice Act, provisions dealing specifically with pre-trial detention, deferred custody and supervision orders, and adult sentencing. These concerns were raised directly with the Minister of Justice and were brought before the Justice Committee. The government has listened carefully to these and other concerns and responded by making the appropriate changes to the previous legislation.
Hear, hear.
Because my colleague, the honourable member from Kitchener Centre, has already given the House a thoughtful and thorough description of the provisions that were found in the former Bill C-4, I will specifically discuss the minor changes that are included in this version of the bill, Mr. Speaker. Firstly, with respect to pre-trial detention, the government recognizes that the current Youth Criminal Justice Act provisions are complex, leading to a varied application of the provisions by the courts. Bill C-4 proposes a much more straightforward approach to pre-trial detention that would have allowed courts to detain a youth awaiting trial if the youth was charged with a serious offence and the court found a substantial likelihood that if released, the youth would either not appear in court when required to do so or would commit a serious offence while awaiting trial. The province's primary concern with Bill C-4's approach was that pre-trial detention would be available for a youth charged with an offence that was not deemed a serious offence. They felt that this could prevent detention of a youth who, although currently charged with a non-serious offence, had a prior history of charges or offending and appeared to be spiraling out of control and thus posing a risk to public safety. I'll be happy.
Order.
And I'll go back to the honourable member for Edmonton St. Albert, who has 6 minutes left to conclude his remarks.
Thank you very much, Mr. Speaker. In my previous comments, I was talking about Bill C-10 and specifically the portion affecting amendments to the Youth Criminal Justice Act. In the old C-4, in the last Parliament, the Justice Committee heard concerns from many of the provincial attorneys general concerning the issue of pre-trial detention. And just to remind the House, the province's primary concern with Bill C-4's approach was that pre-trial detention would not be available for a youth charged with an offence that was not, quote-unquote, a serious offence. But, Mr. Speaker, the provisions in the current bill, the current C-10, address this concern. Under the proposed amendments, pretrial detention of a youth charged with a non-serious offence is possible if the youth has a history that indicates a pattern of either outstanding charges or findings of guilt, and if the court finds that detention is necessary for the protection and safety of the public. This change, Mr. Speaker, would allow for detention of so-called out-of-control youth who pose a danger to society, even if that youth is not presently before the court on a serious offence charge. Moreover, Mr. Speaker, the test for pretrial detention will be self-contained in the Youth Criminal Justice Act, without requiring reference to the Criminal Code provisions, as is currently the case. A second modification to the former Bill C-4 deals with the availability of the Deferred Custody and Supervision Order, which is a Youth Criminal Justice Act sentencing option that allows a young person who would otherwise be sentenced to custody to serve his or her sentence in the community under conditions. If those conditions are violated, the young person can be sent to custody. Mr. Speaker, under the Youth Criminal Justice Act, this order is not available as a sentencing option if the young person has been found guilty of a serious violent offence as currently defined in the Act, as an offence in the commission of which a young person causes or attempts to cause serious bodily harm. Mr. Speaker, the new narrower definition of, quote, serious violent offence proposed in Bill C-4 would have expanded the scope of offences for which deferred custody and supervision orders would be available. However, the provisions in this current bill include the new definition of serious violent offence, but also include a change to the amendments proposed in the former Bill C-4 in order to retain the current law on eligibility for these orders, meaning that a deferred custody and supervision order will not be available if a youth is found guilty of an offence involving either serious bodily harm or an attempt to cause serious bodily harm. I think you agree with me, Mr. Speaker, that these modifications are an improvement over the former Bill C-4. And the third modification since Bill C-4 concerns the adult sentencing provisions in the Youth Criminal Justice Act. The amendments to the former Bill C-4 and contained in this new bill would require a prosecutor to consider seeking an adult sentence for young offenders 14 and older who commit serious violent offences. Prosecutors would also have to inform the court if they decide not to apply for an adult sentence for individuals 14 or older who are convicted of a serious violent offence. When the Crown would apply for an adult sentence, the onus would have been on the Crown to convince the judge that an adult sentence was justified. In part, these amendments, Mr. Speaker, respond to the Supreme Court of Canada ruling in the case of R and DB that certain provisions of the Youth Criminal Justice Act violated Section 7 of the Charter. These presumptive offence provisions placed an onus on a young person found guilty of certain serious violent offences to justify receiving a youth rather than an adult sentence, and to justify the continued protection of their privacy. Mr. Speaker, the proposed amendments remove the presumptive offence provisions from the Youth Criminal Justice Act, as well as other inoperative provisions. They clarify the test for the imposition of an adult sentence and ensure that the onus is on the Crown to satisfy the court as to the appropriateness of an adult sentence. In the former Bill C-4, the proposed test for an adult sentence would have required that a judge be satisfied beyond a reasonable doubt that an adult sentence was necessary. When we were consulting, a number of the provinces expressed the view that beyond a reasonable doubt was too high a standard to meet and was not required by the current case law, and finally would make it significantly more difficult to obtain adult sentences in appropriate circumstances. The current proposals remove reference to the beyond a reasonable doubt standard that had been in the former Bill C-4, thus leaving it up to the courts to determine the appropriate standard of proof, as is the case under the current law, Mr. Speaker. Mr. Speaker, I think all members of this House will agree that the amendments to the Youth Criminal Justice Act included in Bill C-10 are a result of the widespread consultations and respond to the concerns of Canadians. Our government listened to our provincial and territorial counterparts, to provincial attorneys general, Canadians, victims, and have made the necessary changes to this part of Bill C-10. I think all members can agree that the changes I have described and outlined here to the House are reasonable and responsive, and I encourage all honourable members to support all parts of Bill C-10. Thank you, Mr. Speaker.
Questions and comments. Questions et commentaires. The honourable member for Bonavista, Gander, Grand Falls, Windsor.
Thank you, Mr. Speaker, and I want to thank my colleague for his speech. I want to ask him about one of the fundamental elements of this entire bill, this omnibus bill, obviously deals with the issue of mandatory minimums as a deterrent. I would like to ask my honourable colleague that to justify how this is to be a deterrent when it comes to mandatory minimums. We have examples where in certain jurisdictions around North America the death penalty exists, but yet their murder rate is much higher, capital offense rates are much higher than jurisdictions that don't have the death penalty in place. So when you look at situations like that, you have to wonder whether mandatory minimums do serve as that deterrent. Perhaps my colleague can convince me that is the case. Thank you.
The honourable member for Edmonton, St. Albert.
Well, thank you very much, Mr. Speaker, and I thank the honourable member from Newfoundland for his good question. If he was listening to my speech, he would have known that I was talking specifically about changing amendments and provisions to the Youth Criminal Justice Act, not to the minimum mandatory sentence provisions, which I suspect he might be referring to those who traffic in cannabis and other controlled substances. However, notwithstanding the lack of relevance of the question towards my speech, I will attempt to answer it. Certainly, there are no provisions anywhere in Bill C-10 dealing with death sentences, nor ought there be, in my view. That being said, certainly minimum mandatory sentences in appropriate circumstances do deter crime for one very, very simple proposition that appears to be lost on most members of the opposition, and that is an individual, when incarcerated, cannot commit further crimes.
Questions and comments. Questions et commentaires.